But mainly one reason why I feel pretty certain that the court is going to take this cert petition up is because of that statutory interpretation question. It is out of sync with the way other circuits have handled this issue, as I've said. So if this does go to the Supreme Court, I think it'll be quite interesting because we will see a number of presidential immunity related things that could be brought up.
It's the Lawfare podcast, Trump's Trials and Tribulations. I'm Benjamin Wittes, Lawfare's editor-in-chief, with Anna Bower, Lawfare legal fellow and courts correspondent, and Lawfare senior editor Roger Parloff, and a special guest with 6 legs.
I'm being upstaged here, I think. But
the Fly is getting a special guest credit on this show.
Okay.
I'm sorry, Roger.
In a live recording on August 1st, we talked about Mark Meadows' cert petition in his attempt to remove his Fulton County election interference case to federal court. We talked about Trump's briefs in his attempt to vacate the New York verdict under the Supreme Court's immunity decision. And of course, we answered audience questions.
And unfortunately, there's nothing about that Judge Cannon's opinion on its face that is going to offend any judge or that's going to say, gee, there's something categorically wrong here.
Hey, folks. Ben Wittes here from the Mar-a-Lago Ballroom Studio. Now, I know that you think that we have been distracted. I know it. I know you think that an attempted assassination of a former president would rock us back on our heels, that the Israelis killing the leadership in 4 different countries of their enemy organizations would cause us to shift gears, that the president of the United States declining to run for re-election and being replaced by Kamala Harris and sparking coconut memes and $200 million in donations would cause us to lose focus. But we are bitter enders here at Trump Trials and Tribulations. And as long as there is a single case pending in a criminal court against a single former president of the United States, any one, we will be here Thursday afternoons. From the Mar-a-Lago bathroom studio, it's Anna Bower, back in the Scott studio, having left his French resistance days behind him. It's Roger Parloff. And we have a lot to talk about here in the bitter end department. All right, we're going to start. I'm going to surprise you guys. We're going to start with the Georgia case, because that is what no one was expecting us to do. But there was actually action in the Fulton County case, and it was in the United States Supreme Court. Yes, your favorite former chief of staff, who's currently under indictment, filed a cert petition, and Anna Bower read it, so you don't have to. Anna, what did Mark Meadows, represented by none other than former Solicitor General Paul Clement, argue to the United States Supreme Court?
Yeah, it's worth mentioning Mark Meadows brought out the big guns for this cert petition. Paul Clement is one of the most well-known Supreme Court advocates in the country. So he brought in someone. It's basically hiring Paul Clement. You are saying, I really mean business about this. And keep in mind, for folks who don't recall the background here, this is the removal proceedings that have been ongoing in Mark Meadows' criminal charges in Fulton County, Georgia. He was charged there, and then very quickly after he was charged, he tried to remove his proceedings from state court to federal court. And what that means is that he would still be charged with the same charges. It would still be prosecuted by Fani Willis if he is successful in removing this case, but it would just be with a federal judge under federal procedural rules, that kind of thing. He then testified at this hearing last fall. I was there and we wrote about it and talked about it on the podcast. And Judge Jones denied his request. Basically, Judge Jones said, because a big part of the statute that he removed this case under is basically you have to show that you were acting within the scope of office for whatever it is that the state is alleging. And Judge Jones essentially said, no, you weren't acting in the scope of office and you can't remove. And then it went up to the 11th Circuit. The 11th Circuit, in an opinion written notably by Chief Judge Pryor, who is a very conservative member of the court on the 11th Circuit, wrote an opinion in which the panel decided first that the removal statute does not include former federal officials like Mark Meadows. And that's really important because that was a bit of a different kind of decision than other circuits have decided. It doesn't really gel with the way that the 11th Circuit has treated removal cases in the past. And it's kind of a funky statutory interpretation.
Funky is a generous word for it.
Yeah, very generous. It's weird considering the policy considerations, the way basically removal would work in terms of considering the chilling effects on federal office holders even after they leave office. Of course, it's always been the case that there's this concern that if you then immediately wait until the day after they're out of office to indict them or to bring a civil suit against them, that itself will also have a chilling effect while the federal officer is in office. So there's all of these reasons why that first ground that the 11th Circuit decided, which was this weird statutory interpretation decision about saying, okay, well, Mark Meadows, you can't remove because you're a former federal office holder, and Congress has not enacted a statute that allows former federal officials to remove. But then the second ground that they decided on was the under one of the categories of this scope of office test. They said that Mark Meadows had not shown a causal nexus between the federal office and the acts that are alleged in the indictment. So essentially, it goes to this question of whether or not he really was acting under color of federal law, which is the way that the statute kind of, says that it's one of the requirements in terms of whether or not a federal official can remove the case to a federal forum. So those are the two grounds that the 11th Circuit decided on. People were surprised, I think, to hear that Mark Meadows most recently went ahead and petitioned the Supreme Court because it's been a while. That was back in December that the 11th Circuit decided this issue. But the reason that Mark Meadows was able to still appeal is because he got two extensions from the Supreme Court. The reason being that there was the presidential immunity decision that was still pending, which kind of relates to this issue because it's got a scope of office test, maybe a little bit different from this test. It's still kind of unclear because we're dealing with a statute here. We're dealing with presidential immunity there and something that is judicially created. So it's still unclear exactly how these two tests might overlap. But that was pending. There was also all of the disqualification proceedings that were going on in Fulton County. So there were a lot of reasons that Mark Meadows had to say to the court, hey, I'd like an extension to see how all these other things are going to pan out. Ultimately, he did get this extension. So he was able to go ahead and submit this cert petition in the past week. And what he argues in the petition, it very much tracks with the first prong that I was talking about, which is this statutory interpretation interpretation question, he argues, just as I said, that this just doesn't it's not consistent with any of the way that the 11th Circuit has implied in the past that former federal officials can remove. There's been some 11th Circuit cases where it's just been assumed, basically, that even if you're a former federal official, that you can remove. He also cites the fact that in, for example, civil cases where you have like a corporation that's acting under a federal official, that is a case where oftentimes the contract that that person or that corporation was acting under has long, expired, or the work is done. And yet these corporations and civil suits, for example, are still able to remove because they were acting under a federal official at the time of the act. And then you also have just, the policy reasons as well. There's, like I discussed, there's this idea that you have this chilling effect on the work of the federal official, whether or not it's that the suit is taking place while they're in office or after they leave office. And this is where we start getting into the importance of the immunity decision, because they cite to the immunity decision saying that the presidential immunity decision is, underscores this, because that case involves a former president, and the whole case is about the chilling effect that you might have on the executive function if, after a president leaves office, you can then indict him for things that he was doing while he was in office. So there's that kind of argument. And then the second argument goes to this scope of office issue and the causal nexus. One of the things that's interesting here is that in, I believe it was 2011, Congress actually changed the removal statute. So it used to say that a federal official could remove for any act that is done under color of federal office, something to that effect. They changed it so that the text then said, for or relating to any official action. And there's this idea that some circuits have kind of alluded to, that adding this language of relating to means that you've kind of expanded the universe of things that qualify for removal, that you don't have to be as exacting about, what the nexus is between the allegations in the indictment or in the complaint, if it's a civil case, and then whatever it was that the office holder was doing. So they make this argument there and say, basically, the 11th Circuit was too exacting in the way that they, looked at this. They've ignored the fact that Congress changed or amended the statute so that it has a much broader application, and make arguments to that effect, basically saying that the 11th Circuit got it wrong there on that prong as well. And Ben, I think I'm curious to hear if you agree with me, Ben. I think that it seems very likely that the court here will take up this case, because I think that especially it has nothing to do really, I think, with maybe the second issue, which is the decisions about whether or not Mark Meadows was acting in the scope of office, though I do think that the court probably might want to address that. But mainly one reason why I feel pretty certain that the court is going to take this cert petition up is because of that statutory interpretation question. It is out of sync with the way other circuits have handled this issue. As I've said, it just seems entirely inconsistent with a lot of the policy issues. And it just seems really, it's a weird way of deciding this case. And I think the Supreme Court is going to want to have the last word on how to interpret this statute and whether it does apply to former federal officers. So I think it's very likely that the Supreme Court does take this up. And if it does, we're going to get, I think, maybe the first decision that really tells us things like whether or not some of the immunity holdings apply to for example, someone who is acting under the president. They have one paragraph in this brief in which they talk about the evidentiary ruling or rule that the Supreme Court created in the immunity opinion, in which they're saying that even for unofficial prosecutions of unofficial conduct, you still can't bring in official acts evidence. It seems to be the case that Meadows is assuming here that rule would apply to people who are acting under the president, like the White House Chief of Staff. So if this does go to the Supreme Court, I think it'll be quite interesting because we will see a number of presidential immunity related things that could be brought up.
Yeah, so I agree. I don't think it's certain at all that the Supreme Court will grant it, but I do think it is a distinct possibility. And honestly, I don't think it would be a bad thing. I thought the district court opinion was lousy and not especially thoughtful. And I thought the 11th Circuit opinion was worse. The good news is that this actually doesn't affect Trump at all, because Trump has waived his opportunity to seek removal. So this is a Meadows-only issue at this point.
So that's right. Although, again, because of remember that the test here for removal involves there's a fly that keeps landing on my face.
Yeah, it's entertaining everybody.
The test here is kind of like there's a bunch of different elements that are nested within whether or not you can remove, and one of them is whether or not the office holder or former office holder in this case can raise a federal defense. The federal defense at issue is supremacy clause immunity, which is distinct a little bit from presidential immunity. But the point is that Trump has raised a supremacy clause immunity type defense in Fulton County. And if the Supreme Court is going to, have this case that they take up, I think that we're going to learn a lot more about what the Supreme Court is thinking in terms of whether or not Meadows and Trump might be successful on that supremacy clause immunity defense.
No, that's certainly right. But the result of this case will not be the removal of Trump's case to federal court. It will, and that's assuming that Trump's case continues at all. So here's my question. Imagine for a minute that the Supreme Court grants cert that says, no, Mark Meadows should be able to remove. But then Georgia Court of Appeals says, actually, Fani Willis is disqualified entirely from the case. And the case falls apart as a result of the disqualification. Is the joke on Mark Meadows for paying Paul Clement's fee?
Well, I mean, look, we don't know what's going to happen with I don't know, but
that was a joke. You're not supposed to take the question seriously. It was a joke about how much it must cost to get Paul Clement to represent you.
I'm sure it does cost an arm and a leg,
Yep.
So yeah, I don't know. We'll see, but I'm sure. Look, he's got really good representation. And we'll see what happens.
It actually, jokes aside, it has been one of the things that has been a pleasure to watch about the Meadows defense is how wall-to-wall good the representation has been. At the trial court, they have McGuire Woods in there, and at the appellate court, in the federal court, they had George Terwilliger, and it's nice to watch one of these cases that's really well lawyered, and everybody's rooting for that fly, Anna. All right, let us move to Washington, D.C., where absolutely nothing has happened in the January 6th case. However, something is slated to happen, and that's what we scratching our way to news. We're going to talk about tomorrow's news today. Roger, what are we expecting to happen tomorrow?
We're expecting, in effect, the mandate to reach the D.C. Circuit. Apparently, they don't really call it a mandate when a federal case goes back to a federal court. But the 32-day delay will have expired, and something can begin to happen in United States versus Trump, the election interference case again. And so either the DC Circuit will look at it itself, which seems extremely unlikely, or they will send it further back down to Tanya Chutkan, and she will begin to make heads or tails of this. I'm sure she's been studying it, and she will probably begin to schedule some sort of hearing to go through the evidence and or go through the indictment and try to figure out which acts are Trump can be held liable for and which he can't, which are official acts that are for which he is absolutely immune, which are official acts for which he is only presumptively immune, and that presumption can be overcome. So that should begin happening soon.
All right. This brings us to before we do the big thing, which is briefing in the New York case, let's talk briefly about South Florida. Has anything happened in the last week in South Florida? Answer, yes, we have a briefing schedule. Roger, what's going on?
Yeah, the government's brief is due August 27th. Then 30 days after that, Trump's brief, and 21 days after that is the government's reply, the special counsel's reply, and they have not yet set. So that'll bring us to October 17th, assuming that the government doesn't file early. If the government files early, the other dates will move up a little bit, and so it's conceivable you would get oral argument before the election, but often oral argument in the 11th Circuit, I'm told by a practitioner, can be months after the briefing's complete. So I don't know what they have in mind here, and that's about where that stands.
Anna, what do you think we can read anything into the briefing schedule?
I mean, look, I think the one thing that is very certain is that it's unlikely that the 11th Circuit is going to render a decision in this case before the elections, because Jack Smith has not yet sought to expedite the appeal. I think it's unlikely that that is going to happen. And so I think that we aren't going to see the Mar-a-Lago case back in action and back in sorry, fly. I will stop there. I think it's really unlikely that we're going to see this case back in action in Judge Eileen Cannon's court before the election. And I think that Trump, as a result, will continue to say what he has been saying on the campaign trail, in which he has been saying that he won the case.
Which so far he has. It is even one of the truer things that Donald Trump has been known to say. All right, this brings us to the main action of the day or of the week, which occurred in New York criminal court, which is called Supreme Court for reasons just related to the desire to keep people as confused as possible. The president, former president, you will recall, filed a brief asking for the case to be dismissed in light of the Supreme Court ruling. The prosecution, which New York calls the people, filed a brief in response saying, NF way, Trump filed a reply brief. Roger, give us a sense of the argument.
Yeah, the reply brief was just filed a few hours ago. He challenges 6 categories of evidence. I would say the most important is Hope Hicks' testimony. That was certainly had some of the most dramatic stuff. He challenges a Form 278E. That's an Office of Government Ethics form that public officials file, and actually candidates for office file. It's a financial disclosure form. Trump's form in May 2018 had included some information that looks a bit like a garbled admission for purposes of the case. The third category was, or a third category is Madeleine Westerhout's testimony. Westerhout. She was a special assistant to the president, a young woman who sat outside the Oval Office. She testified about some actually things that sounded pretty anodyne. There were things like, but his work habits, how he came to handle his personal affairs from the White House, how he's got packages and filed checks, and the fact that he didn't use a computer and didn't use email. Another category was 4 tweets he issued, or in some cases, threads of tweets. These mainly had to do with what was called the pressure campaign, and they were from 2018. And this was when the government, the people were saying that Trump was pressuring Cohen not to, he hadn't cracked yet, and he was pressuring Cohen not to cooperate with federal prosecutors who were sniffing around. One of those tweets is also another garbled admission, sort of admitting after it had come out that he had reimbursed Cohen for the hush money payment. Then there are 2 more categories that have to do with relating to Cohen's testimony about events after an FEC investigation began. That's the Federal Elections Commission. This was also 2018. This involves Cohen sent a text to Maggie Haberman, and he got it, who is, of course, a New York Times reporter, a private person. He got a text from Jay Sekulow, who's the private attorney for Trump, and he said something disputed to David Pecker, who was the head of AMI, which is the parent company of National Enquirer. He sort of assured David Pecker that Trump had told him that then Attorney General Jeff Sessions is going to take care of all of this FEC investigation. Don't worry about it. And then the last category was Cohen's testimony that had to do with the investigations in 2017 and 2018 by Congress and also by the special counsel's office. And basically, he was explaining why Cohen lied during that period. And he was saying he was sort of staying in step with the joint defense team, with Trump's team. So Trump objects to all of these for various reasons under the decision, and there are up to 5 responses to each category that the people raise. And one is I'm being upstaged here, I think, but
the Fly is getting a special guest credit on this show.
Okay.
I'm sorry, Roger.
There are up to 5 responses. I would say 2 are procedural and 3 are substantive. Procedural argument 1 is that the DA's office Trump waived these objections by not raising them in a timely fashion. That's a really long and winding road and a complicated question. At most, Trump might have waived objections to 4 of the 6 categories. He clearly objected to at least 2 of them. There are 3 substantive responses, which is that the acts aren't official, or the act is official, but the presumptive immunity can be overcome. And the third response is that, yes, it's an official act, but it comes within a section of the Supreme Court ruling that Anna and Ben wrote about called footnote 3. It's this cryptic footnote, but it certainly implies or states that a public record, that you can prove an official act through a public record, as long as you don't sort of then try to go behind that public act with private testimony from private advisors and stuff like that. The argument, the government's argument, really tracked some of the points that Anna and I were making about with respect to footnote 3 and tweets. It's also very relevant to the OGE form, the 278E form. I mean, it's really dispositive to all of those. In the reply brief, Trump is now saying that footnote 3 doesn't really exist. It only refers to a special situation involving bribery. Pay no attention to the man behind the curtain, so we can ignore footnote 3. An argument we anticipated in the piece. Anna stuck in a little section about whether this was really just about bribery or not, and concluded, not really clear. Then the final argument, and it's procedural again, is harmless error, which is the idea that, which is this doctrine that, if there's an error with evidence, and there's no reasonable probability that it would have made a difference to the jury, it's harmless error and you can ignore it. Here, I think that's a pretty strong argument with respect to almost everything except the Hope Hicks testimony. And then he also has an argument that harmless error can't even apply here. It's a structural error. It's a weighty constitutional error. It can't ever be harmless. He doesn't give many examples of where the courts have accepted that. The long story short, if you want my long story short, is that I think that Merchan, there are pretty good arguments for Merchan to rule for the people. The closest question is Hope Hicks. And I think that's the way that the New York courts would go. But boy, if the Supreme Court takes this again, it's really hard to predict. And I would be a little pessimistic. Yeah, so I want to try to summarize the government's argument in a slightly different way, which is most of it is, most of the issues that they raise are waived. Among the rest, a bunch aren't really official at all or are covered by footnote 3. And the sliver that's left, which is basically half of Hope Hicks's testimony, is harmless error. And I think the weakness of that argument is the role that Hope Hicks, I think a lot of it is really strong, and I think they're going to sweep a lot of stuff off the table, at least with Justice Merchan about that.
But the part that I agree with Roger, that the part that they're going to have trouble with is that, Hope Hicks's testimony was significant enough that it featured in the, of course, everything featured in the summation, which went on for 5 hours. But she was not a trivial part of that summation. And, that she cried and that she issued this very devastating testimony that was so devastating that she fell apart after giving it. This was a part of the nucleus of the argument, and maybe a bigger part than it ever should have been, because it actually doesn't bear on the elements of the offense, but they made quite a lot of it. And I think it is hard to say now that, well, if you don't let it in, that doesn't taint the verdict. I do think the better argument with respect to Hope Hicks's testimony, which they also make, is that it's that whether it's official or not, it's overcome by other stuff, advising, while getting advice from your chief aide on public relations matter may be an official function. It's not really an important official function of the president, such that to prosecute it, to use it as evidence of an other crime in the context of, covering up, paying off the porn star you slept with after you faked the records, to do that would encumber the functioning of the risks, encumbering the functioning of the executive branch. And I think that kind of the argument that it's sort of in category 2 and overcomable is better to me than the argument that it's harmless error. If I had to make a prediction, I think they're going to survive. The conviction will survive in front of Justice Merchan, who is likely to proceed to sentencing. And I have less confidence now than I did before that the case will survive on appeal. And I agree with Roger that on direct appeal now to the Supreme Court, this is likely grantable, which it wasn't before, because this is a very significant federal constitutional question, and the Supreme Court won't trust the New York Court of Appeals to be the final arbiter of it. And so I think the likelihood that this gets reviewed by the Supreme Court is now rather high. Interestingly, though, none of that will happen before the election. This is an area where the delay actually arguably hurts Trump, that you can't, if he gets to claim in South Florida, I won that case, and be, as I said to Anna, more or less correct about that up until now, he's going to go to this election or assuming Justice Merchan doesn't overturn the verdict, he's going to go to the election as a convicted felon, and he may well prevail on appeal after that, but that will be after that. Kamala Harris is going to be able to say, convicted felon, I'm a prosecutor, he's a felon, in an uncomplicated way from now to the election. And so that's the flip side of having delayed, is now you don't get to do the appeal in time for the election. I'm sure in the grand scheme of things, the delays have worked to his favor, but on this specific one, I think he may be a little bit like it may have been too clever by half.
Well, right. And also, I think, Roger, correct me if I'm wrong, but Justice Merchan has set for himself a self-imposed deadline of September 6th to decide this issue and then proceed to sentencing shortly thereafter. And so it's not just necessary. Right. But it's very, very close to the election. It's not just that it's happening before the election, it's happening at a critical time right before the election. So I agree with Ben on that. But Ben and Roger both, I'm curious, we've talked a little bit about footnote 3, the argument from the prosecution, and sorry, again, the fly is still here, our special guest. But the argument from the prosecution is that there is a public records exception for evidence that is introduced of official acts, even when the charges relate to unofficial conduct, as is the case in New York. The argument from the defense is that there is no public records exception, and that footnote was just unique to bribery prosecutions. How it may be that Justice Merchan doesn't reach this question at all, because he could just say everything's unofficial or the presumption is overcome, so it doesn't matter.
Or everything's waived.
Or everything's waived, any of those things. But if he does reach this public records exception argument, what's your instinct on how he might rule?
Well, I thought it, both Roberts and Barrett, footnote 3 is Roberts is responding to an argument that Justice Barrett makes. Barrett says, let's take, for instance, bribery. And then he responds about the bribery example. And he uses it. And so both are, it's clear to me that neither is saying bribery is the only place in the world this can happen. And it would be incredibly disingenuous of Roberts to expound upon this and never say, by the way, this only refers to one crime in the whole book, in the whole, code book. And so I can't believe that. The part where he's the more plausible part of Trump's argument is that doesn't the opinion, Trump versus United States, Roberts talks about going through one by one, he goes through the indictment and saying, what about Trump's statements? What about this? Is this tweet admissible? Is that public statement admissible? And so the question arises, well, yeah, why didn't he bring up his own footnote 3 there? And isn't it obvious that the tweets are that you can at least there is sort of is his foothold. But I think that on its face, otherwise, it's crazy.
Yeah, I don't think it can just apply to bribery. I do think what the parameters of it are, as we described in our piece, is completely opaque. And I feel bad for Justice Merchan that he is the first person who is going to have to figure out how to apply this, not merely prospectively, but retrospectively to a case that was tried when this wasn't law. It's a ridiculous position he's in. And so the better part of valor, it seems to me, on his part would be to avoid the question, perhaps by, and I have not gone back through the record to figure out whether as much as foreclosed or waived by the defendant as the prosecution claims, but it may be that if you use that actively, you get rid of a lot of these issues. You are going to be left with some of those Hope Hicks problems, though, and that one he's gonna, the old joke about the district judge and the who goes duck hunting and he shoots the ducks out of the air one by one and then says, I sure hope that was a duck. And that's what the situation that Justice Merchan is. He's going to throw some darts at the wall and, hope it was a target, not a person he was throwing them at. All right. I think we are ready to go to questions, of which there are none in the Q&A. Now, that could be because our fearless leader did not open the questions. So, Anna Hickey, if you have not made the questions available, please do so. And fortunately, I have some questions sent to me by other means, which I will access now, and I will talk like mellifluously and without pausing until I do, because I don't have them in front of me, because I always go to one of the boy, this is unfortunate. Always go to one of the existing questions first. But I didn't do that today. And so here are the pre-submitted questions. Question number 1, has the Supreme Court ever issued a clarification or update to its own previously issued opinion without waiting for a new case to be brought? Are there constitutional, statutory, or institutional barriers to this? The short answer to that question is not updates, but it is a fairly routine matter for the Supreme Court to issue errata, which is to say when there's an error in the opinion for it to correct it. And in fact, I believe it did so a couple times this term with respect to some of the administrative law opinions. It's a fairly routine matter for the Supreme Court to make mistakes, and when those become clear, to just issue a clarified opinion. Second question, for Roger. During your comments about Judge Eileen Cannon, you have commented several times that she is writing her opinions in a stilted and academic way that make them torturous to read and betrays her ambitions for higher judgeship. Now that you may have had more time to read the dismissal, do you still think this is true? And do you think that she is getting the attention from those to whom she is actually writing?
I thought this decision held together. It was, it's not beautiful writing. And I think it was appropriate given that she was overturning, about 150 years of practice, and about 50 years of law, to go into great detail about why she was doing this. So I don't think there was anything over the top. It's sort of neither here that, it's a little stilted by my, that's neither here nor there. A lot of judges are a little, but no, I thought it was, I think what you do see is somebody dodging and weaving through multiple, statutes explaining why this one won't. It's sort of like watching a boxer evade jabs, and it's convincing on its own terms. But at a certain point, you might ask, why is it that all of the answers came out the same way? All 70 answers to all of these minor questions, and everything that people have been using for so long turns out to be mistaken. Could it be that there's a result-oriented quality to this? But, that's not the way it's going to be decided. It's things, the composition of the Supreme Court has changed, and these ideas that she's buying are held by people that have a lot of sway right now. The people that the brief that she is relying on most is Steve Calabrese, who's, basically invented originalism. He's co-founded the Federalist Society. He didn't really invent it, but he's its biggest proselytizer, one of the biggest. And he's had, that gives you an idea of his impact. Mukasey, Ed Meese, who is one of the other key proselytizers for originalism. So these are big figures right now, like it or not. And that's why I just don't know how it's going to play out. I think there've been terrific. Marty Letterman wrote a very good article, and Adam Unikowski wrote a very good article on this. And both of them, I thought, gave stronger arguments for upholding the government's position than the government brief did. That may be because they were simply longer than the government's brief. But how this plays out, I don't know. And unfortunately, there's nothing about that Judge Cannon's opinion on its face that is going to offend any judge, or that's going to say, gee, there's something categorically wrong here.
All right. Anonymous attendee asks, do we know anything about the purported amici that sought leave to file an opposition brief on July 29th, as mentioned in a footnote in Trump's reply brief in the New York case? Well, I haven't read the reply brief yet, but Roger, do we collectively know anything about the purported amici?
No, I don't. But since Trump was asking for a chance to respond, it's apparently somebody supporting the government's case.
All right. Perhaps the same, perhaps another anonymous attendee asks, in light of recent events of the past month, including, of course, the decision in Trump v. U.S. and the dramatic shift in the prospects of a second Trump term, I have a big picture question about you, or we, have been doing the last few months on Trump trials. In the event that Trump loses, but the Supreme Court decision and the potential collapse of the Fulton County case, how do you think you might interpret what you've been doing here? What is the future for presidential accountability short of the ballot box? Is there a future for legislation to remedy some of the problems that have rendered POTUS virtually immune to prosecution for criminal, including seditious, behavior? I'll assume that a constitutional amendment is so unlikely as to be off the table. Likewise, impeachment and conviction has shown itself toothless. Well, I will take this question myself. Our job is on Trump trials and tribulations. The job of Lawfare is broader, of course, because we have all these other things we cover. But the function of Trump trials and tribulations within the Lawfare ecosystem is to track these 4 cases and any other criminal matters that might arise against the former president. And along the way, to treat other issues. And it's all by way of an extended study of the problem of, as you say, presidential accountability in the criminal arena. Sometimes we detour into civil cases when they are particularly significant. Now, it may be, and you raise the possibility, that the prospects of presidential accountability through the criminal process are zero, either because the courts render them zero or because President Trump becomes president again and does it himself. I am open to that possibility. Not in the sense that I think it's a good idea or a good outcome, but in the sense that, I never promised, and I don't promise, that the chronicling of these will lead to some great revelation about how we do presidential accountability, that at the end of the yellow brick road lies, the Emerald City. It could be that at the end of the Emerald Road lies a dead witch, or sometimes a witch hunt doesn't actually catch a witch. And I'm mixing metaphors here, but I think the problem itself is worth studying. And it may be, and it certainly looks more likely than it was 6 months ago, that the after action report on this project of criminally prosecuting a former president is going to say, well, that didn't work. And then we're going to have another question, which is, okay, well, what is the mechanism of accountability for a president? Because, as you say, impeachment has some problems. Some of the other legislative mechanisms that have been talked about, you couldn't get past, and if you could, they'd be subject to constitutional challenge. And so I think there's a really important question at the heart of this, which is, what do you do about a rogue president? And there was a hypothesis ventured at the beginning of the Biden administration by the Justice Department eventually through the Office of Special Counsel, and by 2 state district attorneys, which was that the criminal process has some role in this. And our job, which was admittedly self-appointed, but was my conception of what lawfare should do, for which I hired both Roger and Anna, was that we should chronicle that. And we should, we started before it was a presidential investigation. It was, a bunch of January 6th people. When I hired Roger, it was, hey, we've got this incredible body of prosecutions going on. Let's follow them. Let's really track it. That question was important. I don't know what the answer to that question is. I very much hope the answer is not, I would not mind, actually, if Trump were tried and acquitted. That seems like accountability. I mean, it may not comport with my sense of the evidence, but the case was presented and a judgment was rendered. As Anna will tell you, I was sufficiently at peace with the New York case that I didn't even go to the jury rendering. I was like, I don't need to be there for, I wanted to see the evidence presented. I don't need to see, but I don't need to see Trump convicted. I do need to see that there's a process for presidential accountability. And I think the question very rightly frames the question of whether that still exists. So I will stop there. And if either of you have anything to add, feel free.
Just very briefly, technically, one thing that is available is what people who oppose it call court packing. But that is one thing that can be done without a constitutional amendment. It would require, a tidal wave of one party taking power, the Democratic Party, and that doesn't seem to be in the cards either. But that is a way to do it without a constitutional amendment.
All right. Mark asks, why is the 50-year billionaire network judicial influence effort and success not part of all analysis narrative? I will just say in response to that I think, every question can be asked at many different levels of altitude. And you can ask the same question, why is the speed of the rotation of the Earth and the heat of the sun and climate change not part of the analysis? And the answer is because you have to take on with a question with the focal length of the lens that is most useful for understanding this. We're not social scientists. I'm not somebody who's going to, explain the Trump legal phenomenon in terms of the overall position of the judiciary and why voters elected Republicans who put this kind of judge on this kind of court. Eventually, you have to confront the question in front of you. And with the courts that you have, not the courts that you wish you had. I wish we had Merrick Garland on the Supreme Court instead of Neil Gorsuch. I just do, but you can't revert to that every time you have to answer a question like, does the president have immunity from criminal prosecution? Eventually, you have to treat the court like a court, however hard that may be. Finally, I also think we should always remember that we're a national security legal publication, and we're not a money and politics publication or a critique of the judiciary publication. We're not, strict scrutiny or any number of publications that see their job as to, rail with a raised fist against the heavens. That's not what we do. What we do is we try to study national security legal problems, one of which turned out to be, what happens when you have a rogue president. And we try to give useful guidance about that within the context of the system that we have. And that's, and so you're always thinking about that altitude problem and reducing that altitude problem to a kind of theodicy, why does a good God allow evil? Doesn't it even if when it's right, it's not always all that useful. All right, back to our list of questions. Ooh, this is a long one. Focusing on the president's core powers, where there's absolute immunity, what does this immunity say about the relationship of presidential power to congressional power? Every item in the criminal code is, in fact, an act of Congress, and the president is immune to the force of those acts of Congress. How can this immunity be limited just to the criminal code? An act of Congress is an act of Congress, and the president's power is the president's power, which apparently, forgive the pun, trumps congressional power. Is the president likewise immune to the Vacancies Act and therefore can appoint anyone he or she wishes for whatever reason? Must the president abide by congressional spending limitations where presidential spending is a core presidential power? Immunity isn't just an issue of enforceability, and even if it were, who gets to enforce a breach of the Vacancies Act or any other congressional act? Congress can pass another law, which apparently has little, if any, effect on core presidential powers. Short of impeachment and conviction, is there any congressional power that can stand against the immunity of core presidential powers? Okay, I have a million thoughts on this question, but I want to defer to my colleagues first. Roger, then Anna, what are your thoughts on the biggest of separation of powers questions?
Yeah, I think I'll defer straight to you on this one.
All right. I want to distinguish between presidential immunity and separation of powers issues. The Chief Justice does find immunity in the separation of powers, but they are not synonymous. And to say that there are core presidential powers that Congress cannot regulate is itself an unobjectionable and unremarkable statement. So if Congress wrote a bill saying the president, in giving the State of the Union address, can only use words that have the vowel U in them, we would all agree that is an unconstitutional infringement on presidential power, and the president can give the Constitution gives the president the right to give the State of the Union. It doesn't give Congress the right to tell him how to do it. If Congress criminalized the giving of states of the Union that don't contain the letter U in every word, we would say that statute cannot be enforced. And so a lot of what's in that paragraph is just unobjectionable, generic separation of powers law. And, people have trouble with it. There are aspects of the separation of powers that are uncomfortable, including that there are some irreducible core of presidential power that is unregulatable. But that's the way we have always operated. And by the way, presidents, you can't criminalize vetoing a law, right? That's just not an objectionable proposition, and not even Ketanji Brown Jackson or Sonia Sotomayor object to the idea that there's some unregulatable core of presidential power. The problem with conflating that with immunity, as the question does, is that you make the stakes too high, right? That if we acknowledge that the president has any irreducible core of power, then the world is ending because the president is unaccountable. The problem with immunity is the following. First of all, it presumes the answer to the question. It says, all right, if the president is operating in this space, we're going to assume he's immune, and the burden is on the government to show that it's not. Well, that's a little backwards. We don't do that with the First Amendment, for example. If the government comes after me on some charge and I have a First Amendment defense, we don't presume that the statute is unconstitutional because I say I'm a journalist, right? We assume that the law applies to me, and if I lose, I can appeal. Here, we've flipped the presumption because we've called in an immunity. The second thing which follows from the first is that because we've called it an immunity, we've front-loaded all the appeals. So the immunity question gets litigated before the rest of the case. Well, I think that's wrong. But the problem is not that there is some irreducible core of presidential power that is not regulatable. That's black letter law. All right. We have two more questions. We're going to get through them, and then we're going to end a little bit early because it's only 5:06. Could the U.S. Congress amend the federal rules of evidence to obviate or dispose of the evidentiary rules promulgated by the U.S. Supreme Court in Section 3 and footnote 3 of Trump v. United States, or would the Supreme Court just rule that that public law was unconstitutional? Who wants to take this one?
It's a little hard to on the fly. Let's see. It was a constitutional ruling, so ordinarily a lot of federal evidentiary rules, the Supreme Court ultimately enacts them, but pursuant to authority given to it by Congress, and Congress could overturn it. But here, these rules seem to have constitutional basis, and so I don't think. But I'm doing it on the fly, and I would need to study it closely. So I don't think so, but.
Well, I'm doing it on the fly too, but I don't think I need to study it closely. The Supreme Court essentially overturned all acts of Congress as applied to the president in circumstances in which it declares there to be immunity. It did that without an act of Congress saying that there was immunity. So it is rooting this in the essential qualities of the office and the separation of powers, and therefore no congressional action can change it. And I think you see that in the Biden administration's response, which is to propose a constitutional amendment.
And by the way, we don't want to get rid of footnote 3. It's one of the few things we have on our side.
Yes, footnote 3 is our friend. We want it to grow and prosper and mean ever so much more than it was intended to. All right, last question.
We want lots of little footnotes.
Yes, may footnote 3 prosper and thrive, and and have numerous progeny. With most of the cases placed in hiatus for various reasons, does anyone think the DOJ might pursue Trump's sharing of classified documents in the Bedminster meeting? It seems clear to be outside of immunity for official actions. Great question. Roger, what do you think?
No, let go of New Jersey. It's not going to happen. No, it's over. It's done with. If the case comes back, it either comes back in Florida, or conceivably you could drop. Brian Greer has talked about this a little. Conceivably, you could drop the willful retention counts, which would be a big thing to give up, and just do the obstruction charges. At least some of them, the 1512 charges, you could bring in DC, because there's a 1512I says venue lies where the proceeding was that you obstructed, and the proceeding was the grand jury in DC. So, but no, I would forget about Bedminster.
There's a Cole Porter song somewhere about forget about Bedminster. Anna, do you think there's a hope for Bedminster?
No, I think that there's no hope for Bedminster. If Bedminster was going to happen, it would have happened already. Although I wish that Scott Anderson were here so that he could convince all of us why we are wrong, because Scott Anderson has been the number one Bedminster. I don't know if truther is the right word, but he's been the number one Bedminster prosecution, whatever the word is.
Enthusiast.
Enthusiast. Thank you. Stan. That's, yes, I thought maybe Stan, but can you be a Stan if there's only one Stan within the Stan community? But yes, so Scott Anderson wrote a piece about it a while back, but I think at this point we are done with any possibility for a Bedminster case.
We are going to leave it there. On behalf,
we've reached the outer perimeter.
We've reached the outer perimeter, not of our time frame, though. We're ending 19 minutes early, but we have reached the outer perimeter of our questions. Anything we say from now on is outside our official, is not an official act of lawfare. But I want to say in all seriousness to the people who are joining us in the YouTube community, come into the light. Come into the inner circle. The Mar-a-Lago building is packed with secret documents that you can read here in the inner circle. Become a material supporter of lawfare. And I also want to say we will be back next week, because stuff is going to happen. It's stuff everyone else is going to ignore. But we bitter enders will not be distracted by a presidential election, a war in the Middle East, Russian drones over Ukraine. We will focus on every scrap of paper filed in these increasingly diminished 4 cases until the last syllable of recorded time. From the Mar-a-Lago Ballroom, I'm Benjamin Wittes. For Roger Parloff in the Scott studio, for Anna Bauer in the Mar-a-Lago bathroom studio, and for the fly that has been buzzing around Anna's head for the last 75 minutes. We'll see you next week.